So today we're here to see Scott Rahn of RMO LLP, and we're going to talk to him about the importance of living trusts, get a little background on trusts and estates, and check out his office. So should be fun. 2910. We made it. So here we are at RMO. I'm about to meet with Scott Rahn and discuss probate and trusts. And you can see everything today because it is windy. What a view. On the 29th floor, you can really see Catalina out there. You can see Palos Verdes. Very, very cool. You can see the flight path to LAX. If you see that plane coming down. So here I am. My collar popped. Gonna fix that guy. Okay, so today we're here with Scott Rahn, founder and managing partner of RMO LLP, a national probate litigation firm. And we're here to pick Scott's brain about probate and trust. So Scott, I think the best place to start is to ask you how you got started in the business. Why probate and trust?
It's a great question. I love the practice area in school when we studied trusts and estates, but really I got my first taste of it when I was a second-year lawyer and I had the opportunity to handle a case in probate. And probate's just different. It's a smaller bar. It's a closer, tight-knit community of people who are here to really try and help take care of people who are dealing with a really difficult time in their lives.
So the main reason for our visit today is to talk about living trusts. Mm-hmm. So if you could tell us what a living trust is and then what the pros and cons of a living trust are, that would be great.
So a trust is simply a private contract between the person who creates the trust and the person who's going to administer it for the benefit of the beneficiaries of that trust. The pros of a trust are simple. It costs savings because you don't have to pay the tens of thousands of dollars that you're likely going to have to pay to go through probate when you don't have a trust, and the time savings in not having to go through the probate process, not to mention the headache of having to go through a court-supervised administration. So you save time, you save money, you save headaches. The cons of using a trust, some would say, would be the upfront cost and the upfront effort that it takes to create one. You have to put your wishes down on paper, and you're going to want to pay a good lawyer to put those wishes down to make sure that they represent what you intend for your beneficiaries. Now, are those really cons in my book? No. And they're not cons because if you compare the minimal effort and the minimal investment that it takes to create a trust compared with the tens of thousands of dollars that you're going to pay an administrative cost to go through probate and the year and a half you're going to avoid by not having to go through probate, when you balance those two things, comparing apples to apples, the benefits of a trust far outweigh its cons.
So we're talking about living trusts, and I want to ask the question that is something that comes up for me every day. Why is a living trust the best vehicle to own your primary residence?
A living trust simply allows you to give your asset, give your home, for example, to your beneficiaries, to your children, to your spouse, to your other heirs, your loved ones, without having to go through a lengthy and costly court process. It's cost effective, it's efficient, and it comes with less headache.
So when we talk about going through the court process, going through probate, what are we talking about in terms of time and money?
Probate takes time, it costs money. If you're looking at $1 million home, for example, which is pretty much any home in most parts of California, you're looking at fees of tens of thousands of dollars to the executor who's going to administer that probate. And for the executor's lawyers, they're also going to get tens of thousands of dollars in fees. And on top of that, you're looking at a year and a half.
So in that time, that year and a half while you're waiting for probate to get sorted out, who's taking care of everything?
During the time that you're waiting for probate to get sorted out, the executor is the one who's in charge of everything. So nobody's getting anything. So if the children are your beneficiaries and they're expecting the house, they're not going to get that house or frankly a benefit from that house until that probate administration is completed. So they're going to be waiting those 12 months, 18 months until the probate can be completed and the court orders the house distributed to them. Conversely, with a trust, if you can administer it in 3 months, the children will get the benefit that you intended for them much more quickly, much more cost effectively.
And when we say much more cost effectively, what are we talking about? Setting up a living trust costs
Thousands of dollars.
thousands of dollars. I own my home in a living trust. I know Scott does as
I do
well.
as well, yeah.
There are other benefits to the living trust other than just your primary residence, correct? End of life provisions. What else? What other reasons would there be to set up a living trust?
There's potentially asset protection. You can always put your home into a trust that's not named after you, which may make it more difficult for creditors to find. You should consult an asset protection attorney who specializes in that if that's something that you really want. But really the administration, the time and cost savings, and knowing exactly what's going to happen with your assets because you put it down in black and white.
One of the things we have trouble with as brokers all the time is advising our clients on investing.
Mm-hmm.
And as we have discussed and as we were talking about in this video, living trust for your primary residence, best way to do it. That's what we advise our clients. But a lot of our clients have objections. And one of the objections they have is their lender, or their supposed objection is that they can't do the financing in a living trust initially. And that isn't the case, is that correct?
Yeah, that's not the case. You can do financing through a revocable trust. You may have some issues doing financing with some institutions in an irrevocable trust because some of the provisions that that trust may have. But generally, having a living trust is not going to prevent you from doing financing. There's always a way to make it work.
That's a great point. Could you just really quickly get into the difference between a revocable trust and an irrevocable trust?
Sure. A revocable trust generally is the trust that you're going to create that's going to exist during your lifetime. And then when you decease, when you die, then that trust, because you're no longer able to amend it, becomes irrevocable, meaning it cannot be changed. And because it cannot be changed, and because there are certain limitations on what can be done with an irrevocable trust versus a revocable trust, sometimes some institutions won't lend. So, but if you have a revocable trust, you should be fine.
We have the expert telling us that living trust is the way to go. And we've talked about the pros and cons of the living trust, but I do want to get into the cons of not forming a living trust because that is why you exist. You are here to sort out probate and trust problems. So what are some of the things that you're dealing with right now that
Sure.
could have been avoided pretty simply?
I think one of the big problems that we see and most firms see with a lot of regularity is not funding your property into your trust. So you have a property, you have a trust, you buy the property, you buy it in your own name, and you forget to put it into the trust. So having a conversation with your team, with your broker, with escrow, that I have a trust, my trust should own this property, I want to make sure that it gets properly titled in the name of the trust. Because if you don't put it in the trust, then what ends up happening is one of two things. Either you end up going through that whole probate process that you were trying to avoid by having a trust, or at least in California, you can go through a short form process, possibly called a Hegstand petition, where you can have the property transferred through the probate court into the trust without having to do a full-blown probate, but you still have to go to court. It's still going to cost you thousands and thousands of dollars, but it's going to be short form, so you're going to save some time, you're going to save some money, but you're going to not get the entire savings that you intended by doing the trust in the first place. That's one of the big areas that we see right now.
So it sounds like if you're in this office, you've already made a mistake.
Well, that's all we do on
That's
the probate side, yes.
So, Scott, what other issues are you seeing right now with your practice that we should be aware of as consumers, as brokers, or as just general members of society?
I think one of the biggest, most pressing issues that we're seeing in our probate litigation practice, specifically dealing with financial elder abuse, are cases where somebody who shouldn't be on title is on title, whether it's a neighbor, a friend, a child, a boyfriend, girlfriend.
We get this all the time. It's wild. People call us. It's clear that they probably shouldn't own the property. They've gotten on title through some weird undue process. Please continue.
Yeah, it's a growing problem with the aging demographic, with the higher incidence of Alzheimer's and other dementia. We have an entire sector of our society, our aging society, our seniors, our elders, who are being taken advantage of by any member of society. And you need to be aware of your family members' assets who is in their circle of trust, if new people are befriending them, and understand what's going on with their financial lives, including their real estate lives, and be in front of them and be involved and be aware, because helping to prevent an issue is always going to be easier than trying to rectify it after the fact, when you find out that the caregiver or the nurse has become a co-owner of your grandfather's property.
Yikes. Well, I mean, I think that's a good segue into this comment. We both deal with what is the most expensive asset people have, their home.
Absolutely.
And real estate and the ancillary issues to real estate, such as living trusts, probate, all those sort of things, you have to hire an expert. And I'm here today with Scott because he is an expert. He is qualified to talk about these things, more than qualified to talk about these things. And he is who I would go to if I had a problem. So make sure that when you're hiring people, you look up their background, you look up their credentials, you get references. Scott is the founder and managing director of a national probate and estate litigation firm. He has tons of experience. There are other estate planning attorneys and probate litigators who do not, and there is an easy way to kind of check their credentials. Can you speak on credentials and how you go about making sure you are working with the right person?
Sure. It's a great question. I think it's something most people fail to understand or appreciate. There are different practitioners in the trust and estate space. There are people who do estate planning. Those are the people who prepare the wills and trusts. There are people who do administration, who will do the probates and do the trust administrations. And then there are people who handle the disputes, which is what we do specifically, and handle the problems when they arise, and they arise frequently. And I think it's important for people to think about what they need and who the right person is. Are they doing planning? Are they doing administration after someone has passed? Mm-hmm. Or is there some issue that's arisen, either during someone's lifetime? Perhaps a conservatorship is needed to protect grandma, grandpa, mom or dad, auntie or uncle. Or perhaps after they've passed, you discover that their caregiver, the pool boy, the HVAC guy, the dentist, you name it, we've seen it all. Perhaps there's an issue that needs to be resolved. And knowing what you need is going to help you find the right person.
Yeah, and I like coming to Scott, who is the guy who deals with the actual problems, because in order to deal with the problems, you have to understand every layer of the trust and probate process. And certainly Scott knows how to do estate planning in order to be the best he can be at sorting out problems. Sort of like, I think that the best listing agents make the best buyer's agents, and vice versa. There's always a duality of everyone's role. You have to understand it from every angle in order to be great, and that's why I love Scott.
Thank you. Appreciate it.
Well, thank you, Scott.
So we're back in the office. It was great to talk to Scott about living trusts. And I wanted to show you what an estate plan looks like. And I don't have a better estate plan to show you than mine. So here we go. So here's our estate plan. Comes in a very nice binder. My estate planning attorney, Garan Kirkosian, is the best. Pop a little picture of him in here so you can see him. He looks like Adrian Grenier from Entourage. Anyways, Vince, for those of you who are familiar. So here are the documents that are here. And I'm gonna read this out loud to you. We have the Annie and Brad Keyes Family Trust, that's our living trust, my will, Annie's will, a general durable power of attorney and nomination of conservator of the estate of Brad Keyes, same for Annie, advanced healthcare directive for Brad Keyes, advanced healthcare directive for Annie, certification of Annie and Brad Keyes Family Trust, and list of personal items. So that's what a complete estate plan is, but we are talking about number one, which is the living trust. So there you have it. For the sale and purchase of real estate, you need to be aware how title is held as a buyer and as a seller. As a buyer, you need to know what the obligations of the seller are, depending on how they hold title. And as a seller, you need to know what your obligations are. Disclosure obligations change depending on how you own title. For example, if I own my home in a living trust and I'm selling it and I've been living in the home, my obligations are the same as they would be if I was an individual selling my home, because I have actual knowledge of what has transpired. So I would have to fill out a transfer disclosure statement and a seller property questionnaire. However, if I am the successor trustee of, say, NAR's house, there's NAR right there,
and I've never lived there and I'm just exercising my duties as trustee, my disclosure obligations are a little different because I don't have actual knowledge of what has transpired at her house. I don't know necessarily when mold leaks have happened. I don't know if the chimneys is not structurally stable. I just don't know. So I don't have an obligation to disclose what I don't know, and I don't have an obligation to fill out a transfer disclosure statement or a seller property questionnaire. So as it pertains to living trust, that's just a nice tie-in and something to just mention for people, because all the time people screw this up. They think because they have a living trust, they don't have to do something, or because they have a living trust, they do have to do something. And I see that mistake made every day, and I just want to make a note of it because we are advisors first, and that is how we do business. With that, I'm going to wrap up. Like and subscribe. If you need a good recommendation for trust and estates attorney, I have a great one. If you need a recommendation for a trust and estates litigator, Scott Rahn. And thank you for sticking with us. Appreciate you.